Hi, this is Brian Dolan with law firm Pepper Hamilton. Every month, Pepper partner Greg Novak hosts a webinar for West Legal Ed Center on investment management issues. This month, Mr. Novak will be joined by Pepper attorneys to discuss the topic entitled Protecting Intellectual Property Using Business Process Patents, Trade Secrets, Copyrights, and Trademarks. The panel will discuss the importance of having an IP strategy and IP portfolio, as well as a number of other topics. This podcast is a recording of that webinar. If you're interested in the PowerPoint slides they referenced during the webinar, please visit Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted. Thank you.
Thank you, Emily. This is Greg Novak from Pepper Hamilton. I'm a partner in the financial services group in the New York and Philadelphia offices of Pepper Hamilton. Today I'm joined by two of my partners and two associates who are all focused in the intellectual property arena. We have Peter Wakayama and Lori Harrison, who are in copyrights and trademarks, and then Mike Jones and Joe Hlavacek, who are in the patent arena. And today we're talking about how do we protect the intellectual property that is all over this space. All of us have heard the question, well, what's the secret sauce? Why should I invest in your investment product versus somebody else's? Isn't it just like any other hedge fund, private equity fund, mutual fund, or exchange-traded fund? What is the quote-unquote bet that I'm making, and how are you, the manager, protecting my money? But more importantly, that manager wants to know that when he uses the secret sauce to the benefit of his investors, his employees, contractors, and other people aren't going to steal his efforts that he has put however many years into developing for their personal benefit. In addition to the secret sauce and protecting your investment process, there's also structures, use of computers and technology where the patents might be implicated. And then finally, there's trade secrets. And we're also going to talk a little bit about a recent enactment by the Obama administration, the Federal Trade Secrets Act, which is acting as a supplement to the Uniform Trade Secrets Act, which most of the states have already adopted. So without further ado, I'm going to ask our trademark guys and gals to start us off. Peter, what is a trademark, and why is it so important?
Well, a trademark can be a number of different things. It can be a word, a phrase, a symbol, or a design. We all see them every day around us in our daily interactions, so we know well-known, indeed some famous brands. Even sounds can be trademarked. Many of us can recall the NBC tune. So it covers a wide range of things, Greg. And why are they important? Because, well, brands identify the source of goods and services, and for many companies, the high quality of goods and the services. So they symbolize the goodwill in a company, and for many companies, the trademark or trademark portfolio can be the most valuable asset that the company holds. It's intangibles, including trademarks, rather than the tangibles. So in our materials, you can see that we've listed a few in the financial services arena, in Capital One and Scottrade.
So that's an interesting question. I'll often see pitch books put together by clients, and when you turn to the back and you look at their service providers, they'll have, Capital One, equity provider, Scottrade, trading platform, Pepper Hamilton, legal services, and they'll actually use our logos. Is there a fair use exception for trademark, or do they have to get permission in order to include that in a pitch book, which they're going to be sending out to potential investors? And you have no control as the service provider on how your mark is further being used.
Yes, in the trademark world, there is a fair use doctrine. So you can use a third party's trademark in a fair and factual manner. The line that you have to avoid crossing is what we call the likelihood of confusion line. You don't want to use it in a way that you suggest that there's some type of affiliation, sponsorship, or endorsement that does not exist. But generally speaking, if you're referring to another company or brand, you can use that name. We generally advise clients not to use logos because it isn't necessary to identify, for example, Nike by using the swoosh mark. And I know it's not financial services, but think of your company. You can make a distinction between the word name and the actual design. So, but the risk, generally speaking, is relatively low, even if a design is used, as long as you're not suggesting in some way that there's some type of affiliation or sponsorship or endorsement.
A smart idea is if you are engaging, for example, Pepper Hamilton for legal services, you would want to have some sort of agreement in place consenting to the use of Pepper's trademark in your materials.
So, Lori, tell us about the different types of trademarks that are out there and what we should be focused on as we try to protect, our brands.
Sure. The Trademark Office looks at a spectrum of trademarks going from generic up to fanciful. Financial institutions tend to adopt a trademark that describes a product so that they can immediately tell the consumer what that product is. For example, the money fund, everybody knows what that is. It's a fund of money, right? There's other marks, for example, Apple Bank. That's a more suggestive mark. Apple is a word but has nothing to do with the services or financial services. And Comerica, for example, is an arbitrary or even fanciful word. It doesn't have any dictionary meaning in the U.S., and so that's going to be afforded the highest protection. A mark
like Acura for automobiles.
Exactly.
Okay.
And those fanciful or arbitrary marks are going to be the easiest to protect. In other words, if another party comes along using that mark, and assuming there's not a lot of third-party use of that mark, then it's going to be easier for that trademark owner to say, that's a trademark infringement. Whereas if there's another company using the money fund, they may have a right to use that term in a descriptive manner to describe their goods and services.
So what about acronyms? I mean, you have TD Bank, PNC Bank. Are acronyms useful types of marks, or can they be subject to confusion?
Sure. I mean, they are definitely, we advise clients all the time that acronyms are typically good. They can be subject to confusion, of course, if there is a mark that is similar. You have to be careful. Let's say you pick a PNC, for example. Everybody knows PNC. If there is PND or GNC, there could be variations that could be confusing. But generally, those are considered more protectable than what that could stand for. So that would be a good idea to create a brand around that acronym.
So, okay, I've decided that I want a fanciful mark, and I've done my due diligence and checked with you guys, and you've done the studies to make sure that there is no potential confusion out there in the marketplace. Then what do I do? For those following along with the materials, we're on slide number 6, slide 7.
Sure. So once you decide that internally that you like a mark, the most important thing you could do is invest money in clearing that mark. Trademark rights are distinct from company name rights. So doing a corporate name search is not going to be sufficient to determine whether or not there's a likelihood of confusion, which we can get into. But a corporate name availability, minor differences between capital and advisor will be sufficient to allow companies to coexist as corporations. But in the trademark world, that's not the case. Similarly, Google searches are unreliable, especially the financial services. A lot of financial services companies do not like to have public information about them, so simply Googling them will not provide a lot of information about them. We have clients all the time who claim we do our own search on the United States Patent and Trademark Office website. The software that they have embedded on their website is similarly not very, very good. It does not capture plurals. If you're looking for the mark Acura, for example, it will not pick up Acura, A-K-U-R-A, or A-C-U-R-A-S with a plural. So what we recommend is that you hire a trademark attorney. A trademark attorney has tools to conduct searches. They have proprietary software that they have, licenses from other companies, and we also can do comprehensive search. And this will search not only the trademark register, but also state registrations, common law, news articles, websites, domain names, business names. And
how much does that cost to do a search like that?
Sure. Well, our in-house search, which we do using our software in-house, that can cost about $500 to $1,000 to run the search.
So it's relatively expensive to at least set the line as to whether or not my mark is.
A comprehensive search is a little bit more. It can be $1,500 to $2,000 depending on the exact mark and how complex the results are. But we always tell clients it's much better to invest a couple $1,000s up front than be sued down the line and have to change your name and
Well, or worse, if you end up using a name that turns out to have been associated with a financial fraud,
right.
The last thing you want is to try to have spent thousands of dollars building your own brand only to find out somebody later says, are you affiliated with so-and-so?
Exactly. And you also want to be careful just along that line of international considerations. If you're planning to expand your product or your brand internationally, you may not know, for example, what that mark might translate into in another language, or if anything is going on in that country that might affect the significance of that brand.
The other day I tried to go online and log on to my American Express card account, and I typed in Amex.com, and of course up pops the American Stock Exchange. So your point about domain name availability is important. I'm sure American Express has tried to get the Amex domain for years, and they probably wanted an enormous fortune for it. You still have to type in the full name, AmericanExpress.com, in order to get to American Express. Same with several years ago, a law firm had the initials MLB, and of course Major League Baseball wanted that for its domain, and they reached an interesting financial settlement to allow MLB to be used for Major League Baseball.
Domains can be very expensive, so you want to make sure that that's something that's important to you.
Right. So there, the Google search, I'm assuming, would help, because that'll tell you whether or not there's a domain in particular using.
Yeah, and we always advise at least a domain name search. And clients often do it themselves, but we always make sure that there's domain name availability for what they want to do.
Now, is there any one-stop shopping available internationally on trademark, or do I have to go country by country, or perhaps the EU?
Well, there are. The EU definitely has a uniform trademark called the community trademark, and that includes a number of countries in the EU, and there's also something called the Madrid Protocol, and that includes a number of countries worldwide. And what that is you basically have a home registration or application. So let's say you file for a mark in the U.S., you use that as your home application, and you designate a lot of countries, as many countries as you want. Now, there are benefits to that. It's obviously a lot more streamlined. It costs less money. But there are other issues as well that you don't have counsel in all those countries unless something comes up to see if there are any issues before you file. If the home application, for whatever reason, lapsed or is canceled within the first 5 years of that, what's called international registration, that will affect the rights of that mark in the various countries. So,
but who administers the Madrid Protocol?
The Madrid Protocol is the World Intellectual Property Organization, so it's called WIPO. And what you get is an international registration. We really call it a bundle of rights. So they're all kind of tied together. They each go through their own examination process.
So if I have a U.S. company that is taking its services abroad, would you recommend that they file under the Madrid Protocol with this organization and also in other countries specifically, or is the Madrid Protocol sufficient?
Well, there's not a need if the Madrid Protocol will cover, let's say, the countries that they want to cover, EU, Switzerland, Japan, but there are reasons that you might want to file separately. For example, it might be, unless you're filing in a number of countries, it might not be worthwhile to file in WIPO. It's often a cost-benefit analysis for the client to see what makes the most sense.
Peter, I see all the time someone has a name and then they have TM, which I'm assuming is an actual trademark. But isn't there also a common law trademark that we have a right to that arises from first use?
Yes, Greg. Trademark rights actually arise in the United States from use, not registration. Registration is optional. So if a TM appears next to a mark, that's simply a declaration on the part of someone, maybe the mark owner, that trademark, that word, phrase, similar design is serving as a trademark. TM for goods, SM is used for services. So actually in the financial services industry, if it's services, technically it should be an SM, not a TM. And R in a circle should be used only if the mark is registered with the United States Patent and Trademark Office, the USPTO. But it's very important to bear in mind that rights arise out of use, and a company cannot claim that it's a trademark owner unless it can show use of the mark in commerce in connection with goods or services. And then, if that is occurring, the company should also, in most cases, we recommend obtain a federal registration to bolster those rights, enhance those, what we call common law rights, with federal rights under the Lanham Act that are afforded to a registered trademark.
So what's a watch service? For those of you following along, we're on slide 8.
Yeah, watch services, every trademark owner, for background, every trademark owner has an obligation to police and enforce its trademark, otherwise the rights are vulnerable to being lost by way of unauthorized third-party use. So how does a company do that? A company needs to police through watch service. That can be their own efforts, Google searches, looking at industry reports, industry publications, going to trade shows, basically observing what's happening in the marketplace. But there are companies that provide comprehensive watch reports on a regular basis. These can be ordered on a monthly basis and can be reviewed either by the company or by counsel, and then action can be taken as appropriate if things show up in the watch report that are of concern.
And is that an expensive process to have a watch service on a regular basis?
It's actually relatively inexpensive. For about $1,000 a year, we can order for clients an annual watch service, and then either the reports come to us or it's a decline on a monthly basis. So it is relatively inexpensive. When you think about the value that a trademark can represent for a financial services company, it seems really like a no-brainer to order that kind of report and to pay attention to policing and, of course, enforcing the trademark on a regular basis.
So on slide 9, Lori, there are 3 cases. It looks like Arrow Point Capital and Arrow Point Asset Management and Hana Financial and Hana Bank obviously are confusing names.
Sure. So,
and what happened in each of those cases?
Sure. So these are just a few recent cases. So most cases in this area deal with likelihood of confusion, and the Lanham Act provides a recourse for plaintiffs to bring action against the defendant if they believe that their mark is confusingly similar and used in a way that's going to suggest source or sponsorship of those goods or services. So these are just a few recent cases. The first case is a First Circuit case in 2016. Oriental Financial Group brought a case against Puerto Rico with Oriental Bank. The plaintiff sued this credit union, holding that it was infringing its Oriental mark. It had a series of Oriental marks, and the Puerto Rico banks began using Oriental in a number of their marks. The court held that Oriental Financial owned a family of Oriental marks, and even though Oriental is a term that everybody knows, it had developed a strong brand around that in connection with its financial services, and it held that the bank and the credit union offered similar enough services so that there was confusion. In the next case, in Arrow Point Capital and Arrow Point Asset Management.
Let me stop you there for a second. So what ends up happening then? The Cooperativa de Ahorro y Credito Oriental needed to change its name?
Yes, they said that, I would have to check the exact ruling, but the First Circuit had ruled that the defendant, in this case Cooperativa, needed to make some changes to its name to meet non-infringing.
Now, I notice both of these are circuit court cases. Does this mean that action is brought directly in the circuit court from the Patent and Trademark Office, or do I first have to go through a district court?
Usually it goes through district court and then it's appealed.
So these are on appeal? Okay.
Yeah.
All right. So what happened in Arrow Point?
In Arrow Point, the Third Circuit found that here the defendant, which offered individual investment management services and administrations for hedge funds, was infringing upon the plaintiff, which in this case offered insurance and investment services. And here they did also find confusion. In this case, there had been actual confusion, and they also said that the marks were very similar, Arrow Point and the services. Something to keep in mind here, especially when we're advising clients on what mark to choose, is that the Trademark Office is very conservative, is not well versed in the different financial services. So they might see things as confusingly similar that somebody in the actual industry will not. So in this case, even though somebody might think insurance and investment services were different, they both are in the same general field. So you need to be careful, especially when searching a mark, that you include all of those services.
And then Hana Financial and Hana Bank?
Sure. Hana Financial was actually a Supreme Court case. It was actually the first Supreme Court case that looked at a trademark issue in over 10 years. This issue was not so notable for any trademark ruling, but really answered the question of whether tacking of a previously used trademark was an issue of law or fact. And here they held that Hana Bank, who was the defendant in this case, was able to tack its prior use of a mark. So it had used a mark that was slightly different but similar to Hana Bank in defending its own mark.
All right. So an asset management firm trying to protect its brand or the brand of its product would use trademark. Now we're going to switch to the actual intellectual property behind the brand, and for that, I assume you would have to either use trade secrets, copyright, or some form of patent if it's available. So let's talk about copyright first.
Sure, Greg. So yes, you're correct. Other than trademark, you're left with copyright, trade secret, and patents, and certainly good options, and all of them should be considered for protecting the company's intellectual property. So copyright protects creative works. So it's not a brand, not a phrase, not a word, not a slogan. It's creative subject matter. And under the law, creative subject matter is defined very broadly to include, for example, software, databases, forms, websites, manuals. There's a very low threshold for copyrightability. There only needs to be a small, what we say, modicum of creativity. And once the work, we call it a work, once the work is authored or created, the copyright protection comes into existence immediately for that work.
Wasn't there a famous copyright case where this was, eons ago when I was in law school, where West Publishing tried to claim that the slip opinions and other things that it was publishing were somehow copyrighted, and ultimately the courts held no, there's no claim to the copyright materials, but the digest symbols and the summaries and all those other things are subject to copyright?
Yeah, I think the point that you're focusing on there is that elements, when combined in a creative way, can result in a compilation work. So even if the text of a paragraph in an opinion wasn't protectable under copyright law, what West was doing, or what other publishers often do, is they gather elements of information and they assemble it in a way that is useful but also creative, so they create a compilation. And of course, some other creative elements, for example, there could be some artistic elements that could serve as independently as copyrightable works. So it would depend on the work, but there might have been more than one copyrightable element.
Well, anyone who's ever looked at the Code of Federal Regulations knows that they could stand to use a publisher who actually knows how to do an outline, because I don't know if you've ever noticed, A1, subclause 3, et cetera, are all lined up on the exact same margin. And I would pay for a copyright if they actually move the paragraphing into the right place.
There is an important distinction there, though, which is copyright doesn't protect something that's functional in nature. So if the way information is arranged is dictated largely by function and not by some creative choice on the part of the author or the artist, then it may not be copyrightable, or I should say it's likely that it's not copyrightable. So there has to be something of a creative nature in the material in order for it to qualify for copyright protection.
So the U.S. government publishes on various websites data, and the financial services industry regularly uses that data for backtesting purposes, for other analytics. So data mining on federal sites, I'm assuming, is not protected in any way, shape, or form. But the derivative works that come out of the use of that data are?
That's a complex question. I think first off, there's a question of whether the work is protected under copyright, whether the government entity has a right. So we'd have to take a look at that specific issue. But let's assume for a moment that it's not, and that the user can then use the information and assemble it and use it in a new way. They could create a work, may not be, we use the word derivative, it's a derivative work, but they can create a new original work using those elements. And if they do so in a creative way, it may qualify as a new copyrightable work.
So what's work for hire, Lori?
Sure. A work for hire is, let's say you are the company you hire and you have employees working for you. In these cases, the employer is considered the author if either it's created within the scope of their employment or if it's
So work for hire is a protective doctrine for the employer, not for the employee who has been hired by the employer to create the work.
Correct, and that's why especially a lot of companies, if they hire independent contractors as part of their standard practice, they want to make sure to always obtain a written assignment of your work, of those rights in anything that they create while they're working for you.
Now, in terms of independent contractors, I bring some IT consultants in to help me fix a software problem.
Mm-hmm.
Who owns the fruits of their labors? They or me?
Well, that's exactly what we recommend, is that you make sure that you specify that anything that they create is really owned by you. Otherwise, they can just claim that they're going to own it and they'll take it somewhere else.
So the creator is presumed to be the author or owner, and ownership of the copy is distinct from ownership of a copyright.
Right.
Okay,
In other words, if somebody is holding on to the secret sauce, a manual with all these algorithms or a software copy, that does not mean that they have the right to then go shop it around. Ownership of copyright is distinct from ownership of the actual copy of what you're talking about.
I see. And so the law does not impute the ownership of the intellectual property to the person who holds the piece of paper or the ASCII file or whatever it might be.
Right, but we can talk more about that, as that could obviously have harmful effects anyway if somebody is running around with a paper copy of what you want to protect.
Right. So let's talk about the notices. Now, again, here, Peter, there's a similar common law copyright, right, as opposed to one that is filed with the Patent and Trademark Office.
Well, correct. Yeah. We often don't refer to it as common law copyright because it's a federal law, but you could use that term in comparison to trademarks, where the copyright rights arise upon the moment of authorship. Notice is not required, but it's recommended. It's prudent to put others, especially would-be infringers, on notice that you are claiming copyright. So if the name of your company is ABC, you would have a copyright notice of C in the circle or the word copyright, and the name of your company, and you could also include the year of publication. So copyright, name of company, year of publication. Okay, so let's say I'm a hedge fund manager and I am going to prepare, and I have prepared, a PowerPoint presentation with descriptive material about the manager, the fund, the people, the process, all of that. And I'm doing a 506C general solicitation within the context of a private placement, so don't let anybody get concerned about the fact that we have it up on our website. Should I have every page with a copyright indicated on that page that the whole work is copyrighted, or do I simply need to copyright the cover page? It can't hurt to put on every page. It has to be conspicuous. It needs to be something that a reasonable person would have been expected to see. So if it's buried in the last page at the end of the PowerPoint deck, well, that may not be conspicuous enough. So if it is copied, you may not be able to successfully argue that the infringer knew that there was a copyright assertion and it was on the document. So the best practice is to put it in a conspicuous place. And if you look at the materials around you right now in the office, you probably see a variety of materials on the first page, copyright notice in the footer, maybe in the footer of every page. So
how about in a watermark across the page?
Well, I don't think we need to go that far. Now, we'll talk about trade secrets in a little while, and I think we've all seen confidential proprietary watermarks across pages, so that's a different, that's the use of a different type of legend, and in that case, it's important to be even more conspicuous. So I don't want to jump ahead of where we are, though.
So for all of the hedge fund managers and private equity managers and venture capital managers on the phone, if you haven't done it, on each page of your pitch book, you should have copyright ABC Inc., so that it's clear that each page, especially if the deck gets broken apart or individual pages get downloaded from the internet, that the copyright carries with it. Easy to do. Put it in the automatic footer of your PowerPoint presentation preparer, and that way you don't have to worry about it going forward. All right, let's shift gears now to trade secrets. So, of course, the most well-known trade secret out there is the formula for Coca-Cola. Nobody knows actually what the formula is. Maybe some people do, but nobody's talking about it. So what exactly is a trade secret? I know there's the Uniform Trade Secrets Act, which is a state invention similar to the UCC, but there's also something that President Obama adopted last year in May of 2016, the Federal Trade Secrets Act. So how do all these things work together? Here?
Well, I mean, we still generally look to the Uniform Trade Secrets Act as the definition for what qualifies as a trade secret. The Defend Trade Secrets Act, signed into law in May of last year, is a law that allows trade secret owners to bring a cause of action in federal court. But in the first instance, the plaintiff or the company will have to establish that it actually has ownership of a trade secret. So we would look to the Uniform Trade Secrets Act to guide on that specific issue.
So Coca-Cola formula, pretty clear. Let's talk about, I'm fond of saying that there's really not that much new under the sun in terms of financial services, because there's really only two ways to make money, or three. One is you buy something and you allow it to accrete value over time, an interest function, or you buy low and sell high, or you sell high and buy low to cover. So essentially everything comes down to those three techniques. The question is timing. When do I leg in? When do I leg out? When do I leg out and then leg back in? All of those things are what are the secret sauce. Now, investors want to know what you're going to do with their money. The last thing that they want is a black box, because everybody's afraid of the Bernie Madoff problem. So tell me a little bit about that tension. How do I create the opportunity for my investors to know that it's a black box, yes, but there is actually something happening in that black box that's legitimate, versus making sure that my process retains the protections of the trade secret?
Well, it becomes a question of level of detail. I mean, you can talk about and disclose something in general terms without disclosing your secret sauce. So I think that a company can talk generally about a process, a method, a way of doing business that gives the investor or other third-party basic information, a degree of comfort and understanding of what's happening without the trade secret being fully disclosed. So there can be what we call limited disclosures.
Under a confidentiality agreement, presumably.
Well, it can be limited disclosure without a confidentiality agreement, recognizing that the secret information is being withheld and only general information is being provided.
Yeah, but the talent out there on the investor side and the investor counseling side is very, very high, and reverse engineering is not that difficult to do on a lot of these strategies.
Well, that's an inherent risk in any businesses, right? Once you put information out there, someone might be able to connect the dots in a way that they can figure out what it is that you're doing. And that's where a patent, which Mike and Joe will talk about in a little while, might be the better way of going to protect something rather than using trade secret protection. So it's really a question of, sort of the sliding scale of how much you disclose, how much you're comfortable disclosing, how much you can safely disclose. And if you don't think you can safely disclose it, without the benefit of a confidentiality agreement, then to your point, a non-disclosure agreement or confidentiality agreement would be an added measure of protection when disclosing information that you believe to be a trade secret.
So I disclose to you, I'm Bernie Madoff, and I disclose to you that my secret sauce is basically I'm a Ponzi scheme. Can that be protected by trade secret?
Well, trade secret, then you have a conflict of laws potentially, right? You have what is illegal conduct or allegedly illegal conduct, and is that a process that's violating law? Can it be a trade secret? There may be trade secret elements that a business still has that are not, illegal. So it really would depend on the facts and circumstances, specifically what you're talking about. But generally speaking, not a Ponzi scheme, right?
So, but there are carve-outs, right, for the whistleblower rules under the Trade Secrets Act?
Under the Defend Trade Secrets Act, the federal law, a company is required to, if they want to avail themselves of the protection of the federal statute, they have to let employees know, and others, including independent contractors, that they have rights under the law to, the law doesn't trump their right to disclose in the case of a whistleblower action.
So, again, just putting it all into a package for you guys, slide 14, you want to make sure that your employment agreements and your independent contractor agreements have confidentiality provisions that protect your trade secrets. You also want to make sure that following the recent enforcement action against BlackRock, there's nothing in there that says that they can't disclose because that would be a violation of the whistleblower rules. You want to make sure that non-competes and restrictive covenants protect legitimate trade secrets of the organization, and you probably want to restrict access through physical security limitations, and that means not just paper copies, of course, but also your electronic files. And there is a common law protection, right, here, even if we're not under the federal law or the state law, which is misappropriation of private property.
Yeah, some states haven't adopted the Uniform Trade Secrets Act. It's a very short list, but so chances are, that if you have an issue, you're going to be covered by the Uniform Trade Secrets Act. So yes, common law misappropriation, unfair competition claims might be available, but it's rare that that has to be that's the basis.
So if I bring my secret sauce as a practicing attorney to a particular client, this is how you resolve these conflicts of interest for trading programs, for example, just as an example. And we sell that to the client. I'm assuming that that's not something that can be protected through a trade secret because that's legal advice, right?
Yeah, you're not putting any limitations on the use of that information. It's possible that what you have is a trade secret, but once you put it into commerce and you disclose it without any restrictions, whatever trade secret rights you had would be lost, and you would not be able to enforce or claim that you had a trade secret. So it really comes back to identifying what you have. Does it qualify as a trade secret under the definition of a trade secret? And have you taken reasonable and customary steps to keep it secret? Confidentiality agreements, restrictive license agreements, you're not publishing it freely for people to see. But once you commercialize it, and that's where the tension lies, you might need to commercialize and disclose your trade secret, what you consider your trade secret, to commercialize it. Then if so, you lose those trade secret rights. But you may have the ability for patent to continue to protect it under a patent. So it requires a careful analysis. Is it a trademark? Is it a copyright? Is it a trade secret? Is it more than one of those things? And what type of protection should be applied?
All right, so Lori, tell me, what is the Anti-Cyber Squatting Consumer Protection Act?
Sure. So I'm talking about domains on slide 16. As we said, just because you own the trademark doesn't entitle you to the domain and vice versa. But we have a lot of clients who come and their trademark is being used in another domain that is infringing or infringing upon their rights. So in order to enforce your rights, you have two options. You can either use the Anti-Cyber Squatting Consumer Protection Act or the Uniform Dispute Resolution Policy. The former is a federal act that has elements of that the plaintiff must prove. They must prove that there's bad faith, and they must prove that the defendant registered what they knew to be identical and confusingly similar trademark. This can take a lot longer of a process, but will prevent subsequent registration. The Uniform Dispute Resolution Policy is for clients who are interested in a quicker resolution. It's an expedited administrative proceeding, and in there, similarly, the plaintiff needs to prove that the domain name is identical or confusingly similar to their trademark, that the registrant of the domain has no protectable or legitimate rights to that mark, and again, that they registered it in bad faith. So in evaluating which path to use, it's often a decision whether or not they want to the client wants to shut down that domain right away, or whether or not they want to make sure that there's not subsequent violations as well.
So once again, something that most of us take for granted has become a source of revenue and potential intellectual property fights. Mm-hmm. If you have a squatter sitting on a domain simply because they got there.
Right. They could get there first. There's also a lot of instances where we have former employees, for whatever reason. You want to make sure that if an employee is leaving, that they do not have rights to that domain anymore, and that they're not then using that domain for purposes that do not.
Can we require employees to give up rights to certain domains or to certify on the way out the door that they don't have?
Well, especially if that domain was acquired as part of their scope of work, then I think that that's certainly something that the company can require them to give that up. Of course, they want to keep it. The company would want to keep a close eye and make sure that they don't own anything else. Might be more easily taken care of before they leave than after.
Peter and Lori, thank you very much for that great survey on protecting intellectual property through patents, trademarks, and trade secrets. Now I'd like to shift gears, not patents, I'm sorry, trademarks, copyrights, and trade secrets. Now I'd like to shift gears to patents. So you've got Mike and Joe here. So you heard this whole background about protecting intellectual property through these softer techniques. How does a patent differ? What does a patent bring to the table?
Right. So patents differ in many ways from some of the items of intellectual property that were just discussed. Most notably probably is trade secrets, because while trade secrets, it's critical that you maintain the information as secret. Patents actually require that you disclose to the public what the innovation is. So the patent itself is a legal document. It includes a written description of the invention as well as one or more drawings that illustrate it. Those are to meet the written description and enablement requirements of the patent law. And then a patent also includes claims at the end of the document. And the claims are really what's probably the most important part of the patent, because the claims are what define the metes and bounds, the legal rights that are conveyed by a patent. So for people that are unfamiliar with patents, you can kind of think of it much the same way a land survey lays out the metes and bounds to your real property. The claims in a patent are what lays out the intellectual property rights that are protected by a patent.
So, Joe, what legal rights does patent give us? We're on slide 18, for those of you following along.
Yep. So a patent gives the right to exclude others from making, using, or selling or importing your invention into the United States. Also on the same slide, there's a description of a patent as a contract with society, which was sort of what Mike was getting at. The contract here is you as the inventor, you could keep your idea as a trade secret, not tell anybody about it, especially in a software or some other invention where it's not readily apparent what the invention is. So you could keep it as a trade secret, but the patent office is going to require you to describe it, and the level of detail is one skilled in the art. That's the term they use. So somebody who is an engineer or somebody else working in this subject area could pick up your patent and practice your invention. And in return, the government is going to give you a 20-year monopoly from your earliest priority date.
And can that be extended 20 years?
No.
So I have to modify it in order to get essentially a new patent in order to get the extension.
Right. But the other consideration there is 20 years is a long time. So with trade secrets, a lot of times what you're protecting is what you're doing now, whereas with a patent, you certainly want to protect what you're doing now, but also what you're doing 5 years from now, 10 years from now, up to 20 years from now. So it's forward-looking, and especially in the financial services area, a lot of techniques, as you said, have been around forever. But what we see companies doing is starting to incorporate computing technology, smartwatches, mobile devices. There's a new technology called Bitcoin that came out, and nobody's really using these yet. But what we see financial services companies doing is look at these technologies and say, well, are we going to be using them 5 years from now, 10 years from now? We should start filing patents in this area in anticipation of what we're going to be doing.
But, Greg, to your point about modifications or improvements, a patent owner should be mindful once they file their patent application, to the extent there are modifications or improvements that are made, as the years go by, those can be the basis for new patent filings. So improvements to existing technology are patentable subject matter as well.
But don't I need to get a license from the original patent holder in order to be able to modify that and essentially?
No, the answer is no. You can patent an improvement to someone else's patent, right? But in order for you to practice your invention, you would need a license. So you can get the patent, but you can't practice your patent unless you get a license from the original, kind of the base invention. But likewise, they can't practice your improvement unless they get a license from you.
Right.
So many times in those situations, that's where we end up with cross-licensing opportunities between companies.
So somebody licensed the electrical receptacle for the wall, right? And patents the electrical receptacle, and I patent the three-prong plug, right? But for me to be able to practice my patent of the three-prong plug, I need to be able to have receptacles, so I've got to license the receptacle.
Exactly. Yep.
Okay. On slide 19, you have a list of what is patentable versus not patentable. So let's talk about that a second, especially the point on abstract ideas.
Right. So many people in the patent realm kind of will say the phrase, anything created by man is patentable. We see more recently that there has been some curtailing of patentable subject matter. So what is patentable? It's anything new and useful, process, machine, manufacture, or composition of matter. For this audience, obviously, it's going to be more in the area of new processes or methodologies. But also relating to this, you're not able to patent laws of nature, natural phenomena, or like mathematical formulations. And then even more recently, the Supreme Court had a recent decision that dealt with abstract ideas, and this hit pretty hard in the kind of the financial services, banking, insurance areas. And we're going to get into that a little bit more in some of the slides that are coming up, so I'll kind of leave it at that for now.
Okay, so in order for an idea or an invention to be patentable, it has to meet certain requirements, and what are they, Joe?
So the basic requirements are that it has to be novel and non-obvious. Novel just means that something new hasn't been done before, and that's typically a pretty easy hurdle to pass. You can do a slight variation on something and it might be novel. The bigger challenge is non-obvious, and that is from the standard of somebody who's practicing in the field. So for financial services, somebody in the financial services industry. And you can't take something that was already in the prior art, perhaps already patented, and just do a slight variation or something that would be obvious to somebody skilled in the art. You can't get a patent on that. So in addition to being new, you have to be non-obvious. It's something that we often struggle with the Patent Office because it's somewhat a subjective standard, what is and isn't, and that's where a lot of time is spent during prosecution of a patent, the back and forth with the Patent Office, arguing that something is non-obvious.
So what are the benefits of patent protection?
So the benefits are it basically gives you an exclusionary right to exclude others from practicing the invention, and that can basically protect some of your key technology and the innovation within a company. So companies should kind of look at what they're doing and their product offerings and products themselves to identify key technology that needs to be protected and consider, the most appropriate form of intellectual property, whether that be trade secrets or patents, and then use patents that they're able to obtain as kind of barriers to entry for competition to protect them from others entering the space and offering similar products and services. Other things that benefits of a patent is that you can license it, so it can be a revenue generator for the company. So if there's something that you develop and you're able to obtain patent protection, you can establish a licensing program, which can be very helpful to allow others to use the technology in return for, some royalty payment back to the company. One, I guess, word of caution is you want to be careful on who you're willing to license the technology to. So many times you may not want to license your patented technology to your competitors, but if it has uses kind of outside of your industry, that's an opportunity maybe to use the patent to generate a revenue source.
But does it have to be technology? Can it be an investment process, for example, that could easily be done in one's head if you had that kind of mathematical brain?
Yeah, the answer is absolutely. It can be technology. I was using the term more broadly to encompass processes.
It doesn't have to be use of a computer or
it does not.
communication device or whatever.
Right.
You're really looking at it as a process. That's the technology.
Exactly. Many times processes or business methods are tied to a computer. I mean, that's kind of one of the ways in which you're able to take something out of the realm of this abstract idea and try to make it more tangible. So many times we see that even these processes that form the basis of the patent protection, they are somehow tied to some kind of technology, whether it be computers, internet, some kind of the cloud, those sorts of things.
All right. So let's say that I'm an investment management firm, and my idea is somewhat unique. And I want to take it to the marketplace. And I put on all of the proper disclosures, and I have the copyright, common law copyrights. But somebody tells me that, hey, you know what, so-and-so down the street is doing something very similar to what you're doing. Buying low and selling high. We already talked about that. How do I clear to make sure that I'm not infringing somebody else's patent?
So as Peter mentioned earlier relating to trademarks, there's searching that's available for patents as well. And essentially we refer to it as a patentability search. which is a search of the prior art to ascertain kind of what's out there and whether or not what you believe to be novel and non-obvious is in fact patentable over the prior art. And we have search firms that we use to help us with that. Most of the folks that are in these search firms are former patent examiners, so they're quite familiar with the patent databases that can be searched, how to set up and conduct the search so that you get meaningful search results.
Okay. Or I put my head in the sand and ignore it. What are the risks of that?
Right. So the risk of not doing that is that there may be some prior art that exists that is either, blocks the novelty or the obviousness requirements and makes your invention unpatentable over the prior art. Really, the risk there is that you may have invested a lot of money in R&D or in the patent process itself. Searching can be a way of kind of mitigating or reducing the risk of going forward with the full cost of patent protection and finding out at a much earlier stage whether or not there's a likelihood of success in getting a patent to ultimately issue.
So I get a letter in the mail that says we believe that your process violates a patent that we have, patent number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. What do I do?
So the audience may be surprised that a patent attorney would recommend this, but you should immediately seek counsel and a patent attorney's advice as to whether or not you infringe. Because infringement's a somewhat complicated concept, and someone that's unfamiliar with patents and patent claims will generally have a difficult time ascertaining whether or not there is an infringement. So the first thing you need to do is take the notice letter seriously, get a opinion of counsel as to the validity or of the claims or allegations of infringement. If you think you do infringe, then you may look to try to get a license from the patent owner. It will kind of depend on what they're requesting in the notice letter, whether they want you to cease and desist or whether they may be offering a license. If you don't think you infringe, then there are ways to respond to a letter such as that, explaining why you don't think you infringe and hoping that they'll kind of go away if you're able to convince them that there's not an infringement.
So on slide 24, you talk about different ways that you can challenge patents outside of court. I'm assuming this is where you're the challenger as opposed to the person being challenged. If you're the person being challenged, you have to accept the forum that's been selected, right?
Correct. So if you had received the notice letter like we just talked about, one of the other options available to you are there are certain mechanisms in place at the U.S. Patent Office where you can challenge the validity of a patent. Litigation is a relatively expensive process, and some of these challenges that are available at the Patent Office, although also somewhat expensive, relatively speaking, are much less than a full patent litigation in federal court. So some of the items that we've listed here, there's ex parte re-examination. So essentially you put the application back in re-exam. You have to make a filing at the Patent Office, submit the art that you think invalidates the patent with some arguments explaining why the patent should be invalidated. There are also numerous options available under the American Invents Act that was passed in 2013, such as post-grant review, covered business methods review, and inter partes review. The inter partes review is something that's very popular right now, and a lot of patents in kind of what people would refer to as business method patents have been challenged over the last few years, and many have been invalidated. And I think part of the reason for that, or the high rate of invalidation, is kind of like the low-hanging fruit. These were patents that probably shouldn't have issued in the first place, but after the Supreme Court Alice decision, which addressed patent-eligible subject matter, kind of laid out a new test. A lot of these business method patents fell at the Patent Office.
So tell me about the hedge fund that was shorting the stock of a pharmaceutical company, then filing a petition for an IPR, expecting that the bad news would force a reduction in stock price?
Right. So I mentioned earlier these inter partes review, IPRs as they're referred to. So they've affected different industries in different ways. A lot of these were filed in kind of the banking financial services industry, but there was actually an instance where a hedge fund manager basically put together a number of IPR petitions challenging patents owned by large pharma companies, and he basically, purchased or got options to purchase the stock, filed the IPRs. The stock prices immediately dropped based on the news that key patents protecting drugs were being challenged, and then he shorted the stock. So that's one instance where, someone kind of used, some of the mechanisms available to their financial gain.
Yeah, for those listening on the phone, as a securities lawyer, I would tell you should probably not do that. Because there are laws like Rule 10b-5 that would probably view that as a fraud on the market, but, never know. Okay, let's talk about the Alice Corp. And for those following along, we're up to slide 26.
Right, so Alice Corp versus CLS Banking International is kind of the case I've been referring to. This was a business method patent that was appealed to the Supreme Court. It was kind of good news, bad news for patent owners. The good news was that they confirmed that software and business method patents are patentable subject matter in the United States. Then the bad news was they kind of laid out this test that essentially said it had to be more than a mere abstract idea. And then in typical fashion, the Supreme Court didn't define how one determines what an abstract idea is.
I know it when I see it, right?
Exactly. So the district courts, as you can imagine, have been very busy over the last few years with lots of challenges to the validity of patents under the new Alice test. And so, there's been some good case law that's been developed such that, it's a little bit easier these days to ascertain whether or not a business method or software is going to be patent eligible. But it's still an area of the law. Depending on what court you're in, you can get varied results on, the same set of facts and on the same patent. So, it's an area where, it's difficult to advise clients with certainty on how a certain, application for a patent may come out.
So did the Alice decision result in previously granted patents being invalidated?
Yeah, so it resulted in two things. It resulted in, existing patents being invalidated either in federal court or through one of the challenges at the Patent Office. But it also made it much more difficult for currently pending applications at the Patent Office to make their way through the Patent Office. Because the Patent Office then started applying a new test, a test that didn't exist at the time the patent application was drafted. So, for example, applications we write today have certain materials in them that we've developed over the years to address the Alice issue, whereas applications that were pending at the time didn't have the materials necessary to amend the claims.
And the chart on slide 27, it shows a dramatic drop-off in the number of patents issued in these various financial subclasses. Mm-hmm. The Alice decision, of course, coming in 2014, and you see it's almost a cliff.
Right.
And I'm assuming your practice has also reflected that same.
The answer is not really. So I debated whether to include the chart because it's almost a little misleading. So what happens when you file your patent application, depending on the subject matter in the application, it gets classified in a particular art unit at the Patent Office. And so what you see here are the art units for finance, trading, portfolio selection, insurance. Those areas have shown a large or sharp decrease in the number of filings. But what you'll see on the next slide, and Joe and I will mention, is what we've seen is more of a shift in the patent filings from pure business methods on the process of, either investing, financing, or insurance, to more the underlying technology supporting those. So they're being classified in different art units because of the way they're being drafted today. So there has been a decline, certainly, in these particular art units, but I think to say that the overall industry is filing less or sharply less numbers is probably not a fair go to the next slide.
Yes, slide 28.
So as I was just mentioning, you see that there are less filings, in particular art units, but increased filings in some of the newer technology areas, and some of them that I think are relevant for this audience are mobile wallets, blockchain ledgers, online payment systems, those sorts of things. So the filings we're seeing today are more tied more closely to the underlying technology and the processes that are being executed.
Tell me about the blockchain ledgers. What exactly are they patenting there?
So blockchain, for those that don't know, is actually an open source technology. That means it's available under an open source license. Anybody can use it under fairly reasonable terms. You don't have to pay anybody for using it. Blockchain itself is a distributed ledger that can authenticate and record transactions. So no one person holds the ledger. It's distributed over thousands, if not millions, of different computers. And where we see a lot of focus in the financial service patenting area is figuring out ways of either applying blockchain or modifying it. So cryptography, right now the focus is on payments for blockchain, but people have talked about using it for legal contracts, pretty much
anything.
Any application.
Securities offerings, offering illiquid securities.
Right.
Yeah.
Right. It's very flexible. I mean, we've actually started a practice group here at Pepper, just with attorneys who focus on blockchain issues because we're seeing so much activity in this area. So the challenge for financial service companies is going back to that slide that said novel and non-obvious. What can you build off of this that would meet this criteria, and then you can go ahead and file a patent.
Well, I'd like to thank our presenters today for a very engaging discussion about protecting your intellectual property. We are at the end of the hour, and look forward to your attending next month, where our topic will be all things tax. Have a great day, and talk with you soon.